Here we go. Another high-stakes day in a Texas courtroom. Catherine Welch is back before the judge facing a serious felony DWI. This isn't her first time, we're talking third or more. That marks her as a repeat offender in the eyes of the law, instantly raising the stakes. The big question now. Can she convince the court that she's truly changed? Every word, every gesture in this courtroom could tip the balance between leniency and a harsh sentence. The tension is palpable, and the outcome could reshape her future entirely.
All right, this is cause number 24, DCCR 0122, State of Texas versus Catherine Welch. Ma'am, are you Catherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report, and has everyone had an opportunity to review that report?
We have, Judge.
I have, Your Honor.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum.
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Smallfino has already stated, as well as I received the sentencing memorandum at 5:47 p.m. yesterday. I'm going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight. So.
Well, it was reviewed quite early this morning, but I did review it. Ms. Smallfino, you've had time to review it as well?
Same, Your Honor.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to counsel. Did you both receive those as well?
Yes, sir.
I did.
Okay. Is everyone ready to proceed with sentencing then?
At this point, we're entering the sentencing phase. No jury, no theatrics. Just cold, calculated judgment. Both sides have reviewed the pre-sentence report, which acts like a psychological and behavioral X-ray of the defendant. Every misstep, every improvement, every detail of her past and present is laid bare. What the judge decides next could literally change the rest of Catherine's life, determining not just her freedom but the direction of her future. The courtroom feels heavy with anticipation, every eye fixed on the judge's next words.
Yes, Judge.
Yes.
All right. Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think, our focus here is going to be on the topics that we talked about or write about in the sentencing memo. And, just sort of allowing, if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That
Okay.
is an option that doesn't cost the court anything.
Right.
or the state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No, Your Honor.
All right, then argument.
Judge, I want to...
Listen to the defense attorney here. You can feel how personal this has gotten. He's not just representing a client. He's standing up for her character, her journey, her very soul. 3 years of sobriety, mental health recovery, trauma therapy, all carefully laid out to paint a picture of redemption. But here's the million-dollar question. Will the judge see genuine rehabilitation, or just a repeat offender trying to dodge prison time? Every word, every detail matters, and the courtroom hangs on his argument.
She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When, I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. Sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all of the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report, she felt she needed treatment. She said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. And I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means. And so, because a lot of times, as you know, Judge, private rehabilitation programs will just reject you if you've been clean for 3+ years, as she has. And so they just won't even accept you at all. So I think that was just a misunderstanding or a miscommunication between the probation officer and Catherine. But nonetheless,
This is a delicate legal balancing act. The defense is offering full cooperation, probation programs, therapy, anything short of prison. But keep in mind, this is a second-degree felony, normally carrying a potential sentence of up to 20 years behind bars. Every word spoken in this courtroom could tip the scales between freedom and a cell, making this one of the most critical moments in Catherine's case. The tension is thick, and every argument is under the judge's intense scrutiny.
Willing to do whatever the court chooses here. Additionally, we've been in contact with her current parole officer. They are willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from them. And then finally, Judge, you see, we didn't want to focus too much on support from the community because, again, this isn't just a run-of-the-mill case. This is a different focus. But she is married. She has a family. She recognizes the impact that all of this has had on her family and her relationships, the strain it has put on her husband, both financially and also emotionally. And she accepts responsibility for that and is asking the court to consider this extremely rare position that we're asking the court to take here. Obviously, if the court would like her to address the court, she is happy to do that, or I'm not sure how you can proceed on that.
Okay, thank you. Ms. Malfino?
Judge, I don't envy the position that the court is in this morning. I do take very seriously the comments of Mr. Burks. I take him at his word for that, and I hope that all of those things are true. It's difficult for me as a representative of Jefferson County and the state and the citizens that were on the roads every day to stand up and say, I agree with probation, but I don't disagree with the things that Mr. Gertz has said and the information that is in his sentencing memo. To play the other side of the coin, does it suggest that she received the benefit of the doubt already by me waiving the habitual status that she could have been facing based on her number of priors? Does it seem in good conscience that I can say I ignore all of those priors? Absolutely not. But obviously, we have seen that her multiple trips to the penitentiary have resulted in no change of behavior until hopefully now in these last 3 years. And I do sympathize with Miss Welch as an individual. Again, it's hard for me as a...
Now this is truly fascinating. The prosecutor isn't attacking with anger. She's visibly conflicted. You can almost feel the tension in the room. She knows Catherine might deserve another chance, but her duty is to protect the public. This is what makes courtroom justice so compelling. It's not just law in action, it's morality on full display. So the question hangs in the air. What would you do in her place? Risk granting freedom and hope for change, or play it safe and lock her away for 20 years? Every decision carries weight, and the outcome could change a life forever.
Assistant district attorney, to say that I concur with the punishment being probation, but I don't, again, disagree with the comments that Mr. Gertz has. We've had multiple conversations about this case. I know he's worked very diligently at it. I don't really know, Judge, and that's why it's before you, that putting her in prison for 20 years and her getting out in 2 versus an extensive probation period where she could continue the recovery she's been doing is a better option. But again, I don't know what is in the best interest of public safety. Unfortunately, none of us do. So I would defer to the court's wisdom and whatever you think is appropriate based on the volume of information that you have before you.
All right, thank you.